Happy St. Patrick's Day. This is Angel Lugo. I'm an attorney here in Connecticut. I am going to give you a quick down and dirty rundown on civil protective orders here in Connecticut. So, quick disclaimer, this is not meant as legal advice. This is just what I've seen in my experience in both defending and prosecuting the civil protection orders for clients. So, in Connecticut, you have the ability to ask a judge to grant you what's called a civil protective order. Now, the basis for that law is Connecticut General Statute 46B-16A. And I'm only going to talk about that specific subsection, and that's for, not family related, you're not in a relationship, because if that's the case, then it would fall under a separate section. This is more of when people are strangers and they are not related by blood or marriage, or there's no relationship. So let's say you meet somebody at school and for some reason they're doing certain actions, and you feel that that person has crossed a line, then that would be the type that would fall under that, when you want to have the court intervene and kind of say, hey, please tell this person to stop doing what he's doing. So it's what you would say, the stalking or the type of stuff that happens, and it could be stalking or some type of behavior that you feel has crossed the line. It could be between men and men, women and women, men and women. So it's not gender specific, and so it would be when someone says, look, you can ask for one if you've been sexually abused or there's been a sexual assault, but the one that you see more common is the stalking. And stalking is defined as two or more willful acts performed in a threatening, predatory, or a disturbing manner. So it doesn't have to fit all three. It doesn't have to be threatening, predatory, and disturbing. It could be any of those three. But it's got to be two or more. So if it's just one, it doesn't qualify. So let's say, for example, Johnny sends you a text message saying, hey, come over, I wanna, date you, you're very attractive, and by the way, I've been arrested before for domestic violence. Let's say, for example, it's a crazy hypothetical, but let's say you receive a text like that, and your name is like Mary or Jane. Well, let's say he doesn't text you ever again. You never see him again. It probably wouldn't qualify under the stalking because it's only one incident. But let's say the next day he follows up with another text saying, hey, but Mary or Jane, by the way, I really been thinking about you. I can't, wait to see you. I'll meet you at your house after you get off of work. Well, then that qualifies probably because it's two separate acts. Now, the law says threatening, predatory, or disturbing, or in a disturbing manner. But what's disturbing? I mean, what's disturbing to you might not be disturbing to this person. So the law actually has a couple of examples of disturbing behavior. They say disturbing behavior could be harassment. It could be following. Let's say this person, is tracking your movements. You see him at the mall, then you see him at the grocery store later on, and then somehow he shows up at your annual bowling league event that night. So he's obviously, following you as far as your movements. Lying in wait. You get home and all of a sudden you accidentally run into him. That could be considered lying in wait, surveilling. Let's say that he's in the bushes or has some type of electronic device. These days with all those gadgets, the binoculars, the electronic gadgets that you could get at the Apple store. The tags that there's been a couple of instances where people put the Apple tag in the vehicle, and that lets the other person know where that person's going. It could be he sends you flowers, he sends you candy, he sends you gifts, and you didn't ask him to send any of those, and that could be disturbing to you. And obviously nowadays the ones that you will see most often is the phone, the text messages. If he's texting you, you told him to stop, and he keeps on texting you. So under the law, 46B 16A, you can ask a judge for a protective order, and if you've been the victim of a sexual abuse, sexual assault, or if, or the more common one would be stalking. So, and stalking is defined as two or more events that are performed in a threatening, predatory, or disturbing manner. Disturbing manner could be harassment following, lying in wait, text messages, unwanted gifts. And it doesn't have to be directly through that person. It could be through a third person. So if you get your friend to send her stuff, to text her on your behalf, that could constitute, that qualifies. So, so if the judge schedules that person, what happens is the person goes and files what's called an application. It's an affidavit stating to the judge why you think that person, has, stalked you or sexually assaulted you or sexual abuse, and then you write an affidavit. You have a marshal serve it on that person, and then the judge will set it down for a hearing, because the person you're accusing has a liberty interest as well through our Constitution. So the judge sets it down for a hearing. It can be no longer than 2 weeks after you file your affidavit, and you have a full hearing. It's like a little trial, and you're allowed to present witnesses. You're allowed to testify. You're allowed to bring an attorney. You're allowed to cross-examine that person if they do take the stand. But that person also has a right to bring an attorney and defend themselves. That person has the right to cross-examine you. That person has the right to cross-examine your witnesses. So if the judge finds that, that your behavior caused such person to reasonably fear for his or her physical safety, then he's going to issue that order. Now, what does that mean? Causes such person to reasonably fear for his or her physical safety. Our appellate courts have defined that as not a high burden. It's relatable or analogous to what's called probable cause. If you have proof beyond a reasonable doubt in criminal trials and preponderance of the evidence in civil trials, then probable cause is down here. So it doesn't take much in way of evidence for a judge to issue that order. So with that, if the judge does order, he can order it up to a year. And once that's in effect, if for some reason you break that order, you're facing criminal penalties up to 5 years in jail. It is a felony. The order gets sent to the hometown where the person that filed the application lives, their job. The town where the other person lives also gets notified. The Commissioner of Public Safety gets notified. So everyone in law enforcement is going to have this. And if you have weapons, if you're a big Second Amendment fan and you have guns and ammunition, then you're going to have to turn those in, because you're not allowed to, unless the judge allows it. But usually you have to turn your guns in or transfer them to another person. So this has a lot of consequences if you're the person that's defending it. You could lose your job if you have any type of position where you interact with the public, or you're in law enforcement or public safety, and also it has collateral consequences as far as if you're in immigration, or you're seeking some type of green card, or you're seeking to become a full citizen, naturalization as we call it. So it does have a lot of collateral consequences, and it's not hard to get. As I said, the standard is that a judge finds that there's probable cause, that there's probable cause that you reasonably fear for your physical safety. So, but the judge also has to make a finding that you're likely to continue to intimidate, retaliate, and that you're going to continue with this behavior. So he has to find that you reasonably feared for your physical safety through your actions, and that you're going to continue. You'll probably continue with those actions unless this order gets put in place. Now, the test, it's a subjective objective test. Whether subjective means that I, as a person, individually, for me, does Angel Lugo feel that this person is a danger to them, to myself? And then it's an objective standard as well. Would a reasonable person in my position reasonably fear for their safety? So I guess in summing up, with the Me Too era, there's a lot of awareness these days, and obviously we do not condone any type of domestic violence, harassment, stalking, and there is ways for a person who feels that they are subjected to this to get what we call relief from the court through Connecticut General Statute 46B-16A. But if you are the person who's being accused of some type of harassment that is going to defend the civil protective order, then you probably should consult an attorney immediately, because it is not something that is just going to go away. And if you don't show up to the hearing, it's going to be issued in your absence. It could have a lot of collateral consequences, and there is going to be a stigma if you do not, if you're totally innocent and they put this order on you, you will forever have a civil restraining order on your record. So I hope that this has helped, this short crash course on civil protective orders, the law, who qualifies, what the procedures are. So if you have any questions, hit me up on my Facebook page. I'm Attorney Lugo, signing off on this beautiful St. Paddy's Day.